morning, everybody. Good morning. It is 11 a.m. and we are about to get started. I thought today would be an interesting class. Hopefully you guys will have some interest in it. We wanted to talk about service animals and how that kind of interacts or interplays with buying a property in an association that requires approval or has prohibitions against having animals in a property. It's possible that some of you have done this already. You may have more information than I do, but I've seen it quite a few times. And it's kind of a gray area. I think that's the key to know. So I want to start by going over some of the information that I found in Florida statutes and some of the websites that I thought were pretty helpful, and then allow you guys to ask questions and open it up to the floor in that regard. So I guess to start out, let's think of a scenario. You have a buyer who's buying in an association that prohibits animals, yet this buyer has an animal. And the first question is, well, my animal's different. It's an emotional support animal, or it's a service animal, or something along those lines. And I think that's the first distinction. Emotional support animals and service animals are actually different. The service animal is a lot of a higher standard. It requires certain training, registration, certification, and that's typically the standard that you're going to need in order to get a blanket approval on allowing that service animal to be in the property. The emotional support animal is something that you see a lot of times on airplanes, and sometimes you can even use them and get approval with an association, but it's not quite the same as a service animal. Service animals are quite different. So let me show you guys my screen, and we'll start there. So there is a statute. Actually, that's not the best way to start. Here it is. So here's our statute. This is Florida Statute 413.08, Employment and Related Services for Persons with Disabilities. So this ties in with American with Disabilities Act, fair housing laws, and things of that nature. And in Florida, this is how it is handled. So first and foremost, any real property or portion thereof which is used or occupied or intended, arranged, or designed to be used or occupied as the home, residence, or sleeping place of one or more persons. So that is a standard. It's going to be for rentals as well as purchases. If we keep going down, it talks about an individual with a disability. So this is, you first have to define the person that is applying. So it means a function, or it means a person who has a physical or mental impairment that substantially limits one or more major life activities of the individual, which they explain below. Either one, major life activity is a function such as care of oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. Or two, physical or mental impairment, which is a psychological disorder, condition, disfigurement, anatomical loss that affects one or more bodily functions, or a mental or psychological disorder that meets one of the diagnostic categories specified in the most recent edition of that manual. So, and then C, there's an O on public accommodation, means a common carrier, airplane, motor vehicle, railroad train, motor bus, streetcar, boat. It's there. I'll try not to read the whole thing. So here's the important part, service animal. Service animal means an animal that is trained, so actually trained, to do work or perform tasks for an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. So that's our statute. That's kind of the important part. That's who is treated differently. That's how we kind of meet that standard. So you can kind of notice the big distinction that we're meeting here is between a service animal and an emotional support animal is that training. The training is key. So I did a little bit more digging, and I found this great website. I actually really liked it. This is servicedogcertifications.org. And so this is specifically about Florida. Sunshine State allows service dogs to travel, reside with, and perform daily activities. Aligns with the Federal American Disabilities Act, which provides service dog owners the rights and privacy with their service dogs. The way I always kind of explained it to myself was that if they are a designated service animal, they're not actually considered a pet. They are almost an extension of the person. And that's how they get around pet restrictions and things, because it's no longer considered a pet exclusively. The definition of a service dog is similar to Florida statute, one that is trained to do work. That's what we just read. Service dogs must be trained to perform a task that the person with the disability would otherwise be unable to perform themselves. If a trainer is training the service dog, Florida law allows them the full rights provided. And then identification and registration. So now we're going into the meat and bones of this one, meat and potatoes. We kind of know generally, all right, there's a distinction, service animals and emotional support animals. Seemingly emotional support animals are not covered under the Florida statute. They don't have the same restrictions, but they also don't have the same protections as well. So how do we use this? If we're buying a property or renting a property here in Florida, and we have to apply to an association, or we're planning on buying it, and that we read in the covenants, we're within our condo review period, the covenants say no pets allowed, or pets of all kinds are prohibited. Yet you're looking around the entire building, you're doing your walkthroughs or inspections, and you're seeing that owner has a pet, and that owner has a pet, and that owner has a pet. And you're saying, well, if everyone else is doing it, it must not be that hard. And we have a little, Shih Tzu that we want to bring with us. And so I had this conversation quite a lot. It comes up every couple of weeks, probably. It probably comes up to you guys even more. But, it's what I like to do is I say, number one, is it a service animal? A trained, registered, certified service animal? And I let the buyer understand, well, it's not that, it's more of an emotional support. There's no real training. Say, well, it's technically not covered. However, a lot of people go through these processes, they get it registered, they put it on the application, and then it's very hard for a property manager or board to deny that application because of these statutes and these rules giving people certain protections. They don't want to run afoul of those statutes and get themselves in trouble. So they tend to be conservative with reviewing these applications, and a lot of times they'll just approve it without providing much more questions. So according to Florida statute, documentation that a service animal is trained is not required. Although not mandatory, registration is recommended as it allows easier access to all public accommodations. And I would agree. So when we see a buyer applying to a condo association, if you don't include the registration, the property manager will likely deny you. It's not a requirement, it's not statutory. However, that's how they verify. That's how they're going through their process and saying, well, they provided the registration. They might even ask for a doctor's letter. They might ask for, copies of training, certifications, things like that. They don't have to, but a lot of them do. So you want to make sure your buyer's not putting themselves out there just to kind of get called on it later. Having identification and registration available, though not necessary, mitigates any unexpected problems or harassment. I agree 100%. To protect the service dog owner's privacy, the public cannot inquire about the nature of the service animal's owner's disability, including us. We don't want to ask why and what it's used for. A lot of times a client will volunteer that information, and that's fine, but we don't really need to know the why. We just need to know, all right, you're applying using this certification. Do you have registration? Do you have training proof and things of that nature? Because that could come up on an application. So is this a service animal, and what tasks has the animal been trained to perform? Those are the questions you're allowed to ask. I typically don't even ask the second question. I just want to know, do you have the documentation? Neither business nor private entities may ask personal questions, such as asking the owner to have the animals perform their assigned tasks as demonstration. That's a no-no. Asking the service dog owner to declare their illness or disability. And demanding documentation regarding registration or training. Oh, I guess maybe I was wrong to say that. I think there is a distinction when you're applying to join something. When you're joining a membership or an association, you probably have the right to ask for certain things like that, but it's tricky. It's tricky, and property managers are typically represented by attorneys that will evaluate these things. They still might have leash requirements, service dog behavior requirements, but there are a lot of things that come from a lot of benefits from coming from a service animal. There won't be any service, or there won't be any pet fees, pet deposits, things of that nature, because it's not really a pet. It's considered an extension of the person. So next step, you have a buyer still very interested, maybe doesn't have it registered with any sort of registry, and wants to know, well, is that easy to do? Kind of is. It kind of is. So a service dog can significantly improve a person's quality of life. Not only do they fulfill specific tasks, but they can also provide companionship. We already know kind of who qualifies for a service dog and what are the benefits. It's not legally required. But this is the part that I thought was interesting. How do I choose a reputable service dog registration organization? So if you just do a simple Google search and you say service, oh, it's not popping up, service animal certificate, you'll start getting ads for these. And so you've got the ADA Animal Registry, UnitedServiceDog.com, Petable. These are all seemingly private companies that provide this certification. Here's the ADA.gov to get a little bit more information. But any one of these potentially could work. I think I've used this one in the past. It's a service, right? It looks, they're trying to sell you something. So I always try and remind myself and the client and say, look, there are ways to do this. And, it may or may not meet the definition, but you might be able to get what you want regardless. And it's not that I necessarily agree with these services or want people to spread the truth or make it seem more legitimate than it actually is. But I know a lot of people do it. So I don't want anyone to think that you're saying there's no way to do it. So I'll give you an example. We had a closing and the buyer had a pet. Pets were not allowed. The buyer put the pet on the application for the condo association, and the condo association denied her, just denied her, and said, look, you're not allowed to have pets, we're denying your application. And they tried to get their deposit back. And we said, wait a second, that wasn't I'm trying to think of a word. We basically told her, said, you didn't even try. You didn't give it your best effort. You didn't even give all the certifications that you provided to us. You didn't tell the property manager about your registration, the certificate number, the training. You didn't give them anything to prove that this was anything more than a registered or a non-registered animal. So when we had her reapply and provide that information, the property manager had no choice. They had to approve it, and the closing went through. But the trick on that one is that it stated it in the contract. And that's where you guys can come in really well and kind of make the difference on these closings, is that the buyer knew ahead of time that they had this service animal. The buyer knew they were going to do it, and the seller knew, oh gosh, you have this service, you have this animal, do you have documentation, or are you going to put it on the application? So both buyer and seller knew that this was a big part of the buyer's application and wanted to make sure that it was in the contract. So we added it into the contract under the other terms and conditions. And we said, buyer shall apply to the property manager and include information regarding their service animal. In the event the service animal is denied, buyer may terminate and get their deposit back. But it also required them to provide that registration and certificate. It wouldn't have been a good faith effort without it. So I hope I didn't lose you on that example, but it comes up quite frequently. We had one more recently where the covenant simply said pets of any kind are strictly prohibited. And the buyer had put into the contract that they were going to, buyer to apply with a pet service animal exemption. And, in the event it is prohibited or isn't successful, buyer may terminate and get its deposit back. Well, there wasn't an application. There was no condo application at all. It was just, approval wasn't required. The issue would have been after closing. It would have been after closing as the buyer was moving in. And if the property manager was going to give them a hard time, kind of would have been too late. There would have been no way for the buyer to get out of the deal. So we actually took the 3-day condo review period. We went down to the property manager, we asked these questions, and the property manager told us that there was no application. And so we modified the contract. We reached back out to the listing agent and the seller, and we said, look, the other terms and conditions that we initially wrote aren't applicable because there is no application. We want to change this to say, if we can't get written approval from the association prior to closing, then we reserve the right to terminate. So that's actually an active deal that's still ongoing. Dad, we're talking about service animals. Do you have any war stories about service animals?
There's a couple of condominium lawyers in town that I reach out to when I have this. I was told by one, this is regulated by HUD. I don't know if you already covered that. It's a federal issue. It's not a state issue. It's not a condominium. Well, it is a condominium issue, but it's a federal issue which would supersede this. So
yeah, it's actually the interesting thing in my research is it's an issue across the board, but everyone's kind of taking direction from the federal government and the federal statutes. So there's Florida statutes on this, but they align with the federal statutes. Yeah, it's an interesting one. I actually, one thing I tried to tell people as an example is I said, if Delta can't figure it out, good luck property managers figuring it out. All right, we've got a hand raised. I'll just see if I can unmute you. Go ahead. What's going on?
Hi, Kristen. Can you hear me?
Yes.
Good morning. Christina Fisher speaking.
Oh, hi, Christina.
Hi. I missed the first 2 to 3 minutes. So did you speak upon just specifically the emotional animals?
Yeah, we kind of did. Yes. So there's a distinction. So the emotional support animals don't have the same protections. You can use emotional support animals loosely and potentially get on an airplane or a train. You might be able to get into a restaurant, but technically they have to be a service animal in order. And there is a distinction. The distinction is training. So are they properly trained? Do they have that registration and the certification to back it up?
So to touch on that, which is, I definitely know the difference between the two. The problem is the general public doesn't, they seem to think that emotional is a disability, right? And in some cases, a severe emotional disability could be an actual disability in and of itself. So when you get an average person saying that, is it my understanding that irregardless, it's all about the paperwork and training only, or should they just, can I just tell them, hey?
It's a great question, Christina. So we see this a lot where the rule says one thing, but executing on it and interpreting it is actually much more challenging. So I used this example yesterday regarding homestead. And I said, well, if you're allowed to apply for homestead if it's in a trust. But if the clerk, when you go down there and the clerk says, no, you can't do it, just say thank you and go to the next clerk and ask the same question again. And just keep going down the line until you get the answer you want. And service animals are kind of like that, where there are all these protections. There are 100 laws about it. There's very severe penalties for violating these laws, but not everyone kind of interprets it across the field evenly. And if you've got a property manager that's not really paying attention and they say, look, no pets are not allowed, all of a sudden the buyer's like, wait a second, I'm protected in this. You're violating my constitutional rights. It's very challenging, but the safest thing, and what most companies and property managers and boards will do, is that if you can provide proof that it is a service animal, a disability animal, if you can provide something, a doctor's letter, a registration, a certificate of training, boards will just say, look, I don't know, we approve you. And I draw that comparison to Delta, because Delta doesn't know either. If they can't figure it out, how am I supposed to figure it out?
So just to a live experience, okay?
Okay.
A renter comes to me, right, with an emotional support animal. They talk about it to me. I don't say anything more. They want to rent a condo, which does not allow animals. And I am to say to them, we can go ahead and try this rental if you have proof, because it's not really proof. There is no proof that it's an emotional support. You can get the fake certificates. You can get all that stuff, but that's not a disability animal. It's not for handicap reasons. Truly, it's a different definition. So should we say to them, go ahead and try, or should we say, or can we say, you know what? No, they don't accept pets. It's really tough, because if the minute we bring it up, the selling realtor is not going to advise us to move forward, because they're going to say, I would think, no. I've had them say no to me.
Yeah, it's tricky. What I would want you guys to do is say, all right, you have a emotional support or a service animal. Let's talk to the attorney. Let's talk about it. Let me put you in touch with Christian and figure out what your rights are and kind of how we need to handle this. Because what I like to do is when I get on the phone, I say, you know, the client's bringing it up. I'm not asking them, hey, is this a service animal? In fact, what they're doing is they're asking for my legal advice, my opinion on their particular situation. So I'm not violating any sort of laws by kind of going through this with them, because they're bringing it up. But I want them to talk to me because I want to go through the differences. And what I told a buyer recently is I said, look, I don't think most of the animals on airplanes these days are emotional. They're not true service dogs. They're just not. They are support animals, and they're different. So a lot of people get away with it. Now, you use the word a fake certification or fake registration. It's not that they're fake, it's that there's really no database. There's no central database for some of this stuff. You just got a registration.
Right. My mother got it from her veterinary years ago, so the dog could fly for free.
Yeah, I mean, I see people do it on every flight I'm on. Absolutely. Property managers, they tend to have a lawyer involved. They're looking at it more specifically. They have a little bit more to lose. So I would want a buyer to have all of that up front, because if for some reason the property manager denies the application, I don't want any surprises. I want the buyer to have all that information up front, and I want it to be protected in the contract. Does that make sense, Dad? Is that how you always think about it?
That's how I look at it. I mean, I had a friend who was deaf, and she had a service animal for that. And I remember her saying it was quite expensive to buy the service animal. It was like $4,000, and this was probably 20 years ago. You know, versus support, which could be any level of anxiety, I suppose. I just texted a friend of mine who knows more about this, and actually I'm meeting one of your uncles who works at HUD tonight, so I can bring it up. So we can follow up on that.
Yeah, definitely. And so I'm going to share a screen. Someone asked me about a pig. Now the statute says service animal means an animal that is trained to do work or perform tasks for an individual with a disability. So a pig is an animal, a parrot is an animal, a dog, a cat, any of those things potentially are animals. Now, you run the risk of someone thinking that you're crazy, you're making it up, that no way is that real. But you have every right. And so this note in the comments here said the HOA constantly harassed them, even with the support registration. Nothing in the HOA docs concerning pigs. The buyer hired an attorney and won. Typically, buyers will win those because you can't ask too many questions. You can only ask so many, and the property manager has to have like concrete evidence that this is not a service animal. Yet they can't ask anything. So it's this real catch-22, and a lot of times the property manager and the attorneys that represent them will simply say, you just have to approve it. And so that's where Christina comes up with the fake registrations, is that if you have something, it's usually enough, but not enough for you guys. I want you adding something into the contract saying, if, buyer has registered their animal as a support animal, if for some reason the property manager were to deny application, buyer may get their money back. I want it in there. I want something in there. Someone else says, let's see, I'll read it in real time. We ran into this with a purchase as well as rental regarding an emotional support animal. The HOA required documentation from a licensed professional, same for the owners of the rental. Documentation provided, HOA approved, owner approved rental. I was under the impression they couldn't say no as long as the documentation was real. Whether they properly verified or vetted documentation, I don't know. Yeah, I would agree with that. So if you have something to give the property manager, they're likely going to approve you. And that's why you see all these animals on planes, because there's so many downsides with denying it. And if a buyer can simply go online to get a registered animal within 5 minutes, then we really can't be fighting it much. It's like, we can't ask, we can't really force, training isn't required, but it kind of is. It's a mess. You'll notice a lot of similarities to the class we had last week regarding the new Florida statute for certain non-foreign principles, where the big concerns are, okay, we're prohibited from selling real property in Florida, certain real property, to certain people that are from foreign countries, but I can't ask them any questions without potentially discriminating against them. It's this real catch-22 where I just don't know how to do it. And so the safest thing to do is to have a general go over things with a buyer or a seller and say, all right, buyer, here's the property. I've given you the covenants. You have financials. You have all this. Just so you know, there are a couple of problems. We can't have pets. You can't rent, and you can't be from these certain countries. If you have any problems with that, let me know, and we can talk to the attorney. Something like that would work. Having disclosures, notices, and then a lot of times buyers will bring it up to you. The dog will be with them, be at the hotel. They'll mention it, saying, "Oh, he's a service animal. Don't worry about him." And so you just want to bring it up in passing and say, "Hey, just so you know, you're going to want to have the proper documentation because this condo won't approve you otherwise." And listing agents kind of need to know the same thing. Make sure the buyer's applying on time, and that, what are they applying for and who's on their application. So I hope that's helpful. I think it's a really wild kind of unknown, but the key is an open dialogue without being too open. You can only ask so many questions.
I always recommend my clients, Christian, to check this out during the rescission period. And it's a smell
the
test.
3-day condo review period.
Yeah. And if you have something, it's a sliding slope. The more legitimate it looks, the more legitimate the service. If you have a service versus a comfort animal, that's more believable, especially when the disability is quite obvious. It gets too tricky when it gets into post-traumatic stress.
I remember your friend of yours, Dad. He was parking in a handicap spot, and he may not have had his handicap sticker, and the police tried to stop him, and he took his leg off and said, "I promise, I'm a handicap."
They still gave him a hard time.
Still gave him a hard time. Yeah. Christina, did you have something else?
I just wanted, you were just touched upon the foreign principle, and in a private conversation that you and I had, I kind of seared this sentence into my mind. I thought it was so good. I've shared it with many other realtors. But you said a great way to go about it is simply to hand them the form that you provided. And say, by the way, if this is applicable to you, you may not be able to purchase in the state of Florida. Please read it. And not ask anything at all. And we don't want their information. Just if it's applicable to you, you may not be able to purchase. And if they have other questions, then send them to the attorney. Otherwise, most people are just, honestly, they're going to sign it, and which is protective for us.
Yeah. No, it's right, Christina. You were worried about, well, if I'm not allowed to ask, how do I protect them? How do I protect myself? And we came up with, just give them the notice. Say, hey, look, this just came out. It is effective currently. If it applies to you, let's talk to an attorney. Let's make sure that we talk to someone. Let's not waste any time making offers on property until we resolve these things.
Yeah,
There's no duty to ask. There's just, and you bury that along with there's 8,000 other disclosures we have to give.
Exactly. There are a lot of disclosures we have to give. This is just one of them, and I made that point. Actually, Dad, I'm glad you brought that up. I'm on the NABOR Legal Forms Committee, and I brought that up to all the other members. And I said, we're already making disclosures about permits, FERPTA, warranties, open or insurance claims. This is just one more of those. It's pretty extreme, but it's still just one more. The seller needs to know, the buyer wants to know, is this going to be a problem? Let's disclose it. So as an update to last week, the NABOR Forms Committee did approve adding a disclosure to the purchase and sale agreements. It's going to be pretty straightforward. I don't know exactly when those forms will go live. My guess is it'll be the end of the month by the time all the vendors get it out there. But you'll start seeing on new contracts the disclosure about the 692.202 regarding certain foreign principles. There is a possibility that the law will, or the court will issue an injunction to allow more time for the statute to be, evaluated for constitutional, issues. So I don't know exactly what's going to happen. I think there might be a hearing today about it. But in the meantime, the notice is really helpful, and it just tells them, hey, look, you should probably know a little bit more about section, 692.202 if one of these things were to apply to you. So I hope that was helpful. I think the key on these service animal things is there's a lot of information online. It is a very restrictive statute because there's only so many questions you can ask. But what I want my buyers to know, look, you got to be prepared. You got to make sure that this isn't just your pet, that you're actually providing all the information that might be necessary for them to validate that it's a service animal. That's the key. Emotional support is different. We want to make sure, do you have enough documentation? Not that they can ask you for it, but do you have the documentation that it is truly a service animal? Because if it's not, pets are prohibited. It's really
one thing to look at, Christian, is whether or not there are other service or comfort animals at the condominium complex already. They can't unevenly enforce this rule.
Well, and it shows a history of how they've handled it, how they've handled these applications. It's
What's
helpful.
their procedure?
But what you and I talk about, Dad, is I don't want anyone to assume that simply because they can do it, I can do it. It's really not that way. It's fair, not equal. That's what you always told me in comparison to my siblings. Fair, not equal.
Equal, I don't remember that part.
Yeah, no, not equal. Definitely not equal. All right. Well, good luck, everybody. If something comes up, please don't hesitate to reach out to us. We'd love to help you. Amazingly, we have continued to stay somewhat busy. It looks like if you've got the right kind of properties down here, they're still selling, even though we're all the way, halfway through July already. So I hope that people are, working with clients and improving on, finding them a home or selling their current place. But if you need us in that process, if you have any questions, don't hesitate to reach out. All right. Thank you. Bye, guys.
Take it easy. Bye now.